Today in court, the state tried to hide behind Section 204, but when asked to prove the witness, there was nothing, no testimony. There is no evidence, just silence, and that silence said everything.
They say Mr. Gwabini said, and this has got nothing to do with his application, my lord. I am simply responding because this was raised by the state, but it's just a collateral issue. It is not even a facta probandi, facts that are relevant to the facts in issue. No, this has got nothing to do with that. But let me respond, because I simply want to clear the mist. The state says, Mr. Gwabini told, the state says, according to the version of Mr. Kininda, Mr. Gwabini could not come to court because he feared for his life. That is what the state said. Now, that information from Mr. Gwabini, from Mr. Kininda, Brigadier Kininda, it's a hearsay. And the credibility of that information depends on what the originator of that information would come and say. Mr. Gwabini comes to court here, and I specifically put to him, Mr. Gwabini, the state has told the court that you did not come to court to come testify on the behalf of the Section 204 because you are afraid of your life. Mr. Gwabini says, no, they are lying, blatantly lying, because I have been to their offices 3 times. Actually, for the 3rd time, I had to hire a vehicle to come to court here on myself. How could then a fearful person, a person who was fearing for his life, would have done that? And this is the owner of the information that has been peddled at court, in a sense that he's afraid to come. No, he says, no, that's a lie. I went to their offices. They are the ones who actually have been chasing me away in all the instances that have been here. For the first time when I came here, they read some statement that I couldn't understand, and I told them, no. Not in my name. I would not be agreeing with what you want me to go and do, because then you're saying to me, I should go tell the court something which is not real. Then they said, no, go back and think. And that is done in concurrence with the prosecution. Very sad. For the second time, that is also done with the concurrence of the prosecution. Very sad as well. For the 3rd time, goes to the office of the Director of Public Prosecution, as per the arrangement of the prosecutors and investigating team in this matter. He comes to court here. One of the investigating trial sergeant Mohula says to him, Gwabini, go, please, we don't want you here, go. Why are they chasing him away? Why are they chasing him away? Because this is their Section 204 witness. A Section 204 witness, according to them, comes to them and say, no, I'm here, can you please take me to court? I'm eager to go and tell the court what I know about this case. Then they say, no, Mr. Gwabini, can you please go. I would have imagined how Mr. Mkhola actually said that, Mr. Gwabini, please do not make noise. Let us not make a scene. Can you please go. That is what they did. Then they leave him in a ledge because they realize that he was not a good witness for them. And not only not a good witness for them because he had to come and change what he had initially told to them. No, simply because he told them nothing. He had to come here and speak to what he knows about this case. But because of the efforts that have tried in vain to say things that he did not know in favor of the state, they could not hold him. He became a hot potato in their hands. That is the reason why the state decided not to use him as a Section 204 witness. And they made him available to the defense. Then the defense picked him up from the trash place, cleaned him and said, Mr. Gwabini, you will not be coming to testify for us you'll be coming to testify about what you know in this case. Can you please come and assist the court to come to a just, equitable, and a justifiable finding? You came testified. As I've said, my lord, the state is requesting this court to embark on a process which is a trial and error process. These accused, they are not guinea pigs. Are not here as guinea pigs. The procedure is very specific. Prove the statement, establish the basis of the statement, and then proceed to do whatever that you want to do with that witness. The state says the interest of justice dictates that I don't refer to that shake matter. They're referring to Hepworth, they're referring to the shake matter, referring to the multi-choice matter. They're referring to a whole lot of array of matters, the Dlamini, the others, Jubert and Skitechat. They are saying it is in the interest of justice that they be allowed to cross-examine on the content of the statement that allegedly Mr. Gwabini made. But still, who said that they cannot do that? Nobody said that. There is only, however, one test that they have to pass or fail before they get into the statement of Mr. Gwabini. And that is what this was all about. And very interestingly, I remember now, on Tuesday when we reconvened, when the state had to start to make submissions, then the court said, Mr. Baloyi, we basically saw that you can prove the statement, not so. They said, no, my lord, I've prepared head of arguments. And then the court said, no, but Mr. Baloyi, we would be expecting you to prove that statement. Then said, no, my lord, I think we had agreed with my colleagues that we should file heads of argument. I've already done that. And then may I be allowed the opportunity to go through my statement. Then the court, I think, in his brilliant mind, gave him the benefit of a doubt, thinking that probably he will come up with something extraordinary, exceptional, that will demonstrate that maybe there's another process that he would have come up with based on authority, well-recognized authority, through which a witness statement could be embarked upon in trying to deal with the content of such a statement with a view to try and prove the credibility or to discredit the witness who is alleged to have made that statement. As I've said, my lord, in the context of my submission, none of that has come. We still back to square one. Prove the statement. I would therefore submit, my lord, as I end, that fairness of a trial simply also dictates, in respect of the cases that the state has referred to, the Hepworth, the Sheikhs, the Skitechat, the multi-choice, the Dlaminis, and etc. These are all cases that basically refer to the concept of a fair trial. And indeed, the fair trial also dictates that if there's a specific procedure that has been tried and tested and it is in place and it is authority, that procedure cannot be deviated upon for flimsy reasons. Number one. Number two, start the cases, my lords, as fakir and non-mawere. In other words, do not change what is standing. Do not move what has been regarded as law at that particular moment in time. The state had not brought forward any specific authority to say, this is my authority. We're now moving away from the fact that if I wanted to discredit this witness, then I can simply embark upon that without proving that statement. Fairness of a trial also dictates that if there's a standing process that has been recognized for all these years and it is authority, such should be complied with, my lord. Otherwise, the processes that are put in place in order to safeguard the smooth of trials and everything will be turned into a mockery if in one circumstances one party goes to the east, the next time it goes to the west, the next time it goes to the east, and Mpumalanga, njalo njalo. No, that is not like that, my lord. As I conclude, my lord, I would therefore humbly submit that there's nothing that the state has come up with here. There's nothing new subsequent to the submission that I made earlier on, which was based on my objection that the state has come up with here. Even now, the state has not made any case for an exception to the rule, which is prove the statement before you get into it, my lord. Thank you.
Yes.
Let's stop sugarcoating this because real people are bleeding while the state plays legal games. What Advocate Baloyi is doing in this court is not prosecution, it is prolonged cruelty. It is the reckless wielding of state power without the discipline, care, or competence that justice demands. For years now, the Senzo Meyiwa case has been turned into a revolving door of pain. The accused are left in limbo, their lives suspended. The Meyiwa family is forced to relive trauma over and over again. And the public is fed confusion instead of truth. And now we are told about a Section 204 witness, a witness the state did not even bother to call. That is not just shocking. That is dangerous. Section 204 does not mean trust us. It does not mean believe the state. And it certainly does not mean we'll prove it later. Section 204 only means one thing. The witness must testify and be tested under cross-examination. Without that, there is nothing. There is no evidence, no credibility, no case. Today, Advocate Mnisi did what any responsible court officer should do. He said, prove it. And when the state was asked to stand on evidence instead of narrative, there was silence. That silence was not accidental. It was exposure. You cannot destroy lives on drafts, rumors, or alleged statements. You cannot persecute first and investigate later. And you cannot heal a grieving family by dragging a broken case through endless court dates. If this case collapses, and it is cracking in front of our eyes, the blame must sit squarely where it belongs, with a prosecution that chose shortcuts over substance. Senzo Meyiwa deserves justice built on truth. His family deserves closure built on integrity. The accused deserve a fair trial built on proved facts, not legal smoke. Until that happens, what we are witnessing here is not justice delayed, it is justice abused. Can a court rely on a Section 204 witness who never testified? At what point does prosecutorial failure become injustice? Is the state protecting the truth or protecting itself? Does the Meyiwa family get closure from delays or deeper pain? Should accountability exist when prosecution errors ruin lives? Drop your thoughts below, but keep it factual and respectful. Justice demands clarity, not noise. To every viewer who keeps returning to this channel, thank you. This platform exists because you value truth over noise, law over theatrics, and justice over convenience. These conversations are not easy, but they are necessary. We analyze not to be inflamed, but to demand accountability, because lives, freedom, and a grieving family are on the line. If this analysis resonates with you, subscribe, join the channel, or support through Super Thanks. Your support keeps this space independent, fearless, and fact-driven. I'm Skybridge. Until next time, goodbye.